Okay, so in this video, I have two sources. I have a book and I have an article. So I want to give you the sources first and then go back and just talk about what we're going to talk about. Okay, so this is the source, the book, Anatomy of the Law by Lon Fuller. Pretty good book so far. I haven't finished reading it, but I wanted to talk about a couple things in it. And then we have this article from the University of Michigan Law School, University of Michigan Law School's Scholarship Repository, 2002. Statutes with Multiple Personality Disorders, the Value of Ambiguity in Statutory Design and Interpretation. Here's the link. I'll put this link as well as a link to the book in the notes. So if you want to go look at those, you can find them. And when it says the value of ambiguity, you may be thinking the value to you, but they're talking about the value that someone else gets, like the legislator or the departments or the courts, in writing vague laws. Okay, the value they have in it, not the value we have in it, because it's not good for us, but it's good for them. They gain something from it. So in Statutes with Multiple Personality Disorders, it talks about how whenever the Congress writes legislation, they have usually an intent when they write it, but they write it in a way that it's vague. And so when the agencies and the departments and the instrumentalities are trying to apply the legislatures, the laws, they apply it in a way that they have interpreted the meaning to be. So the agencies, departments, and instrumentalities, which are the corporations, which are tools of the government, when they are trying to figure out what to do with these laws, they interpret them in a way that's applicable to their particular job functions. And then if there's an issue and the courts are involved, the courts do not go back to the intent the legislator had when they wrote the law. They go to the department's interpretation of the law, and they side always with the department and its interpretation. Therefore, we have statutes with multiple personality disorders. So statutes that are created with a certain thing in mind, but written so vaguely that then they can be interpreted to mean something completely different. And then the courts side with the interpretation and not the intention. So in the book Anatomy of the Law, this is page 32, and it's free at archive.org. You can find this book, and it cites a couple of examples that are really good to help you understand what all this means. So let's just start with the examples. Suppose the legislature passes a statute which makes it a misdemeanor, quote, to sleep in any railroad station, end quote. Two cases are brought to court. One involves an alcoholic derelict who came to the station dragging a tattered blanket, spread himself out for the night, and was arrested while his eyes were still open. In the other case, a neat and orderly traveler waiting at midnight for a train that was 5 hours overdue had just fallen asleep sitting upright when he was arrested. Has either of these men violated the statute, and if so, which? It is likely that the legislator would have any way of answering this question that would not be available to a court. So I believe he's asking, so in other words, couldn't the legislator have made its intent more specific so that the intent couldn't be interpreted in a way that it was not intended. So if the case seems easy on the principle that sleep means sleep and not lying down in order to go to sleep, consider the following problem. So in the above, the man who was a paying man who fell asleep probably accidentally sitting up because his train was 5 hours late, a paying customer, he would rightfully be arrested and taken and fined or put in jail for falling asleep at the train station, which seems wrong. It seems like this was not really the intent. But the man who drug his blanket into the train station with the intent of going to sleep, who had not quite fallen asleep yet, it would seem that on principle, he would not have violated the law, which they seem like they're opposite, right? So consider the following problem. A sightseeing tourist visits a colonial mansion that has a sign reading, "Washington slept here." When he returns home, the tourist consults his history books and discovers that although Washington did indeed go to bed in the house in question, he lay awake all night trying to work out some plan to defeat the redcoats. Is the tourist entitled to a return of the admission fee on the ground that he was induced to pay by a false statement? So then we get into these issues with courts and how courts are applying the law. They're implying the interpretation instead of the intent. And another really good book to read is Constitutional Law as Fiction by LaRue. And he talks about how congressional interpretations are based on usually opinion, non-factual information instead of the actual facts. Okay, so for example, we find that Congress, whose delegated power then delegates or redelegates its powers to the various agencies, departments, and instrumentalities, whereas the Constitution says that the Constitution is the law of the land, and that the United States can make legislate for itself. So, if the Constitution is the law of the land, then all the legislation that is passed by Congress has to comply with the Constitution. And if that's the case, which we know it is, then we have to look at whether or not the things they're passing are vague, and if they've been interpreted, and if any of its powers have been delegated to other departments. For example, in the Constitution, the Congress has the power to legislate, but then does it turn around and redelegate that power to another department or institution, because delegated powers cannot be delegated, and that's a legal maxim, and has also been cited in case law. Okay, so we have, for example, in many of the federal statutes, codes, regulations, the word individual, and individual is not usually defined, and so then the Congress delegates the power to do certain things to individuals, to departments, agencies, and instrumentalities, whether positive law or not positive. So then we're faced with the question of whether or not Congress can delegate the power of taxation to an instrumentality or a department or an agency, and has those instrumentalities, departments, or agencies then interpreted the law to mean what it wants it to mean instead of what the intent was, and was the intent in compliance with the laws of the Constitution. And sometimes you can write to some of these agencies or instrumentalities and ask them why they're sending you this, and they say, well, Congress gave us the power to do this to individuals, to apply this law to individuals, and the courts will side with the the agencies, departments, and instrumentalities. Okay, so here we're in Anatomy of the Law, and we're on page 24, so I've gone backwards a little bit. And what I want you to look at is, it's talking here about this court decision, Charles Evans Hughes, Associate Justice of the Supreme Court of the United States, 1910 to 1916, Chief Justice from 1930 to 41, once declared, "We are under a constitution, but the constitution is what the judges say it is." The notion back of these quotations is essentially the same as that of the familiar saying, "The king can do no wrong." In an absolute monarchy, this means not that the king cannot act mistakenly or immorally, but that he cannot act illegally, since it is he who makes the law. So if he says what the law is, then it's impossible for him to break the law. So if the courts say what the law is, then it's impossible for the legislature to break the law, which I think is also mentioned in the article Statutes with Multiple Personality Disorders. If we grant to the courts an unlimited power to give meaning to the words of the law at the point where these words are converted into action, the problem of removing the gap between the law as human behavior and law as words on paper seems to be solved. The word and deed have become one, so we find Gray insisting that a proper definition of law conceives of it as the rules applied to the courts in the decision of litigated controversies. Holmes' predicted theory of law. Okay, the most famous expression of this point of view is Holmes' predictive theory of law. So it's saying that the courts have unlimited ability to interpret the meaning of words in the Constitution as well as in the court cases. So here we have the word sleep. And you have a court deciding, well, what does sleep mean? And it could be that the guy who wasn't sleeping had an intent to sleep, so he was sleeping. And the guy who didn't have an intent to sleep but fell asleep, that he was sleeping also. And the court can decide whether or not the man should get his money back based on the word sleep. Okay, and so when we have a constitution that's written for the benefit of the people, and the courts judges are chosen by the president and put into lifetime tenure by the president, then we have courts that will always side with whatever that president wants or whatever enlarges the federal government. So I find it interesting, though, that the Constitution does not require judges to be citizens of the United States. They only require them to have good behavior. However, it does require that the president, the representatives, and the senators to have a citizenship of the United States. And I find that interesting because that's as if they're acknowledging that there are some people who are capital C citizens of the United States and some people who are not capital C citizens of the United States, because they specifically state that representatives, senators, and president must be citizens of the United States, but judges, when it comes to judges, they're silent on it. They only have to have good behavior. In my opinion, that is because citizens of the United States are not the sovereign people. The citizen of the United States are the people in the military who gave up most of their rights to serve and be of service to the United States collectively, or the United States of America, the individual states. Okay, so this is a good article if you're looking for more information on the statutes and the court decisions and why they make the decisions they make, how they give intent. The legislature gives intent but allows their vagueness to be interpreted by the departments in any way that they see fit, and how the courts make their decisions based on the interpretation and not the intent. If you read these things, it starts becoming quite clear why people like me and you without an oath can always end up losing in court. Okay, so the reason why they're called statutes with multiple personalities is because they're easily changed based on the various interpretations that the court might have. And so one department can interpret a law to mean one thing, another department can interpret the law to mean something completely different, and then an instrumentality can interpret the law to mean something else. So when an instrumentality interprets the law, when it says individuals in the law to mean every single person on earth, then the court will side with that. Okay, of course we know that the United States and the departments and the courts of the United States cannot make law for the entire earth. They can only make laws for the lands to which they were given jurisdiction over, which are the seat of government and the places purchased for forts, which means the instrumentalities off federal lands have no jurisdiction. And so when the courts side with these instrumentalities, the instrumentalities aren't even on the federal lands. So when the instrumentalities are given delegated powers, and then these powers are off federal lands, then when they interpret the word individual, they're interpreting it to mean every single person in America. When Congress wasn't even given the power to make law for every single person in America, they were only given the power to make law for the seat and places purchased for forts. And this is part of the problem that we're in, and the fraud that keeps occurring is that Congress allows for their laws to be vague so that the departments can interpret them in any way they want, knowing that the courts are going to side with the departments. And therefore, they are allowing delegated powers to be delegated and redelegated and delegated again, which goes against the maxim of law that delegated powers cannot be delegated. Okay, so that I think is it for this video. I think I said everything that I wanted to say, and this applies to all of the instrumentalities working off of federal lands, that they basically have no power at all. And they're come back when you write to them and ask them what power they have. They says Congress gives them the power too, and Congress's writings are vague for one, and two, they cannot delegate a power not delegated, or they can't delegate a power delegated to them. And so they're delegating powers that they don't have, and they can't delegate a power that they do have to someone else anyway. So there you have it, and share my videos if you like. If you want to post a link of my videos on your website, you can do that. I appreciate it if you not copy the videos and post a copy of the video, because then it won't lead people back to my channel, but you're welcome to post links that come back to my channel. And please encourage people to like, share, and subscribe. My intent is to educate and bring people knowledge, and if not exact knowledge, then at least some direction for people to look into and think about and consider and ponder the ramifications of what's being said. Okay, so there you have it, and you guys like, share, subscribe. Have a great day. Have a Merry Christmas.